Disclaimer: the content provided on this channel is for general informational and educational purposes only. It is not legal advice. I am not a licensed attorney. Viewing this content, commenting, or engaging in any communication with the creator of this channel does not create an attorney-client relationship, nor is any communication considered privileged or confidential. The law is complex and varies significantly by jurisdiction. The information presented may not be applicable in your specific state or country. For advice on your individual legal situation or issue, you must consult with a licensed attorney in your jurisdiction. Do not act or refrain from acting based on the content of this channel.
You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided for you. How many times have you heard that? On TV, in movies, maybe you've even heard it in person. It's a phrase so deeply burned into the American psyche that we almost take it for granted. It feels like a right that's existed since the dawn of the Republic, etched in stone alongside the Constitution itself. But it's not. That fundamental protection, that shield between you and the immense power of the state, was born from the desperate, last-ditch legal battle of a man who was, by all accounts, a nobody. A drifter, a petty criminal whose name would have been completely forgotten by history if not for one thing. A confession, scribbled on a piece of paper in a stuffy Arizona police station. A confession he gave because nobody ever told him he had the right not to. The story of your rights is the story of America itself. The freedoms you enjoy every single day. The right to speak your mind, to be treated equally, to be safe in your own home. These weren't just handed down from on high. They were fought for. In tense courtrooms by brilliant lawyers and ordinary people who were pushed to their limits and decided to push back. These legal battles are the hidden architecture of your life. They decide who you can marry, what you can say online, what your kids learn in school, and what happens when you have the worst day of your life and see flashing lights in your rearview mirror. Over the next 10 parts, we are going on a journey through the most explosive, controversial, and transformative legal cases in American history. And this isn't going to be a dry, boring history lesson. This is a series of true stories, packed with drama, injustice, and heroic moments that fundamentally changed what it means to live in the United States. By the end of this series, you won't just know about these cases. You'll understand the very fabric of your own freedom. You'll understand the power you hold as a citizen and the constant, fragile struggle to protect it. And our journey begins in Phoenix, Arizona, March 1963. A young woman working at a movie theater is walking home late at night when a car pulls up. She's dragged inside, her hands are tied, and she's driven out to the desert where she is brutally assaulted. The police are under immense pressure to find the monster who did this. 10 days later, they catch a break. They track a car matching the description to a 23-year-old man named Ernesto Miranda. Now let's be clear. Ernesto Miranda was not a good guy. He had a long rap sheet, a history of crime, and a deeply troubled past. He was, in the eyes of the police, the perfect suspect. They bring him into an interrogation room, and for 2 straight hours they question him. There's no physical violence, no beating with a rubber hose like in old gangster movies. But imagine the pressure. You're alone. You're cut off. 2 detectives are firing questions at you, telling you that you're cooked, that they have an eyewitness, that you might as well just come clean. Ernesto Miranda, a man with only an 8th grade education, didn't know he could ask for a lawyer. He didn't know he could just stop talking. He thought he had to answer their questions. So he did. He confessed to everything. The police handed him a pre-written form with a typed statement at the top. This statement has been made voluntarily, with full knowledge of my legal rights. Understanding any statement I make may be used against me. He signed it. At trial, that signed confession was the star witness for the prosecution. It was an open and shut case. The jury convicted him in less than an hour, and he was sentenced to 20 to 30 years in prison. Justice served. End of story. Except it wasn't. A court-appointed lawyer named Alvin Moore took on Miranda's appeal. Moore looked at the case and saw something deeply wrong. He argued that Miranda's confession wasn't truly voluntary. How could it be? The man didn't even know what his rights were. It's like asking someone to play a game without telling them the rules. The entire system was stacked against him from the moment he walked into that room. The Arizona Supreme Court disagreed. They upheld the conviction, saying Miranda never specifically asked for a lawyer, so his rights weren't violated. For almost any other case, that would have been the end. A lost cause for a forgotten man. But this idea, this question of what voluntary truly means, was so fundamental that it caught the attention of the American Civil Liberties Union. they decided to take this case all the way to the final authority, the Supreme Court of the United States. In 1966, the case of Miranda v. Arizona landed before the 9 justices in Washington, D.C. The central question was monumental. Does the Fifth Amendment's protection against self-incrimination, the right to not be a witness against yourself, extend into the closed-door environment of a police interrogation room? The government argued that as long as the confession wasn't beaten out of a suspect, it was fair game. But Miranda's lawyers argued that psychological coercion is just as powerful as physical coercion. The inherent pressure of being in police custody, alone and ignorant of your rights, is enough to make anyone confess to anything. The nation's legal community was on the edge of its seat. The court was deeply divided. On June 13, 1966, Chief Justice Earl Warren delivered the 5-4 majority opinion. It was a bombshell. He wrote that the interrogation room creates an inherently intimidating atmosphere that cannot be otherwise than to subjugate the individual to the will of his examiner. To combat this, he laid out a clear, unmistakable set of rules. Before any questioning can begin, a person in custody must be warned in clear and unequivocal terms that they have the right to remain silent, that anything they say can be used against them, and that they have the right to an attorney, even if they can't afford one. The Miranda warning was born. The backlash was immediate and ferocious. Police departments across the country were outraged. They claimed the court was coddling criminals and tying the hands of law enforcement. Future President Richard Nixon made it a campaign issue, promising to appoint judges who would be tougher on crime. Critics predicted that guilty suspects would simply lawyer up, confessions would dry up, and countless criminals would walk free on a technicality. But a funny thing happened. The world didn't end. Police adapted. They professionalized. The Miranda warning became a routine, a box to check. And it created a clear nationwide standard for how interrogations should be conducted. More importantly, it seeped into the culture. Every cop show, from Dragnet to Law and Order, made it a mandatory part of every arrest scene. The words became an anthem of American justice, a reminder that even when you are at your most vulnerable, accused of the most terrible things, you still have rights. The system still has to play by the rules. But what about the man at the center of it all? What happened to Ernesto Miranda? This is where the story takes its most ironic, tragic turn. The Supreme Court's ruling overturned his conviction. His confession was thrown out. But his legal troubles weren't over. The state of Arizona decided to retry him. This time, without the confession, they used other evidence, including testimony from his common-law wife. And once again, Ernesto Miranda was found guilty and sent back to prison. He was paroled in 1972. He tried to cash in on his fame, selling autographed Miranda warning cards for $1.50. But his freedom was short-lived. In 1976, during a card game in a seedy Phoenix bar, a fight broke out. Ernesto Miranda was stabbed to death. He was 34 years old. And here is the final brutal irony. Police arrested a suspect for his murder. As they took him into custody, they pulled out a card and read him his rights. The rights that existed only because of the man he was suspected of killing. The suspect, exercising his newfound constitutional protections, chose to remain silent, requested a lawyer, and was later released due to a lack of evidence. No one was ever convicted for the murder of Ernesto Miranda. The system he helped create, in its own strange and impartial way, worked against him in the end. A stark reminder that the law is a double-edged sword, designed to protect everyone, the guilty and the innocent, the victim and sometimes even the killer. But what happens when the law's protections seem to exist only on paper? What happens when you're accused of a crime, but you're so broke, so utterly destitute, that you can't afford the one person who can help you navigate the system? A lawyer. Before 1963, for millions of Americans, the answer was simple: you were on your own. Unless you were charged with a capital crime, a crime punishable by death, the state had no obligation to provide you with legal counsel. The Sixth Amendment guaranteed the right to an attorney, sure, but the prevailing interpretation was that it only guaranteed your right to hire one. If you couldn't afford it, that was your problem. It was a system that created two tiers of justice, one for the rich and one for the poor. And it would take one of the most unlikely figures in American history to tear it all down, a man who was anything but a hero. His name was Clarence Earl Gideon, and to be blunt, he was a nobody. Born in Missouri, he'd run away from home as a teenager and spent the next 40 years drifting across the country. He was a gambler, a drifter, an occasional laborer, and a frequent inmate. By the time he was 51, he had a rap sheet filled with petty crimes, having served prison time on 4 separate occasions for burglary and theft. He was a man who lived on the margins of society, a ghost in the American system. In the summer of 1961, Gideon found himself in Panama City, Florida, working odd jobs. On June 3rd, someone broke into the Bay Harbor pool room. The culprit smashed a cigarette machine and a jukebox, and stole a few bottles of wine and about $60 in cash from the register. It was a minor crime, the kind that happens every day in every city. But a witness claimed he saw Clarence Gideon inside the pool hall early that morning. That was enough for the police. Gideon was arrested and charged with breaking and entering with the intent to commit a misdemeanor. When Gideon appeared in court, he was a thin, gray-haired man with a face etched by a hard life. He stood before Judge Robert McCrary alone, and he made a simple request. He said, "Your Honor, I request this court to appoint counsel to represent me in this trial." The judge's reply would echo through history. "Mr. Gideon," he said, "I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense." Gideon was stunned. He replied, "The United States Supreme Court says I am entitled to be represented by counsel." The judge was unmoved. The trial would proceed, and Clarence Gideon would have to defend himself. What followed was a legal train wreck. Gideon tried his best. He tried to make an opening statement. He tried to cross-examine the prosecution's witnesses, but he had no idea what he was doing. He didn't understand the rules of evidence. He didn't know how to challenge testimony or poke holes in the prosecution's case. He was like a man trying to perform surgery with a butter knife. The prosecutor, by contrast, was a trained professional who ran circles around him. The key witness, the man who claimed to have seen Gideon in the pool hall, was barely challenged. The jury listened, and after a short deliberation, they came back with the only verdict they could: guilty. Clarence Earl Gideon was sentenced to 5 years in the Florida State Penitentiary. For most people, that would have been the end of the story. Another forgotten man swallowed by the system. But in that prison cell, something ignited in Clarence Gideon. It wasn't legal genius. It was a stubborn, unshakable belief that he had been wronged. He believed the Constitution meant what it said, and that he had been denied a fundamental right. So he went to the prison library. He read law books. He studied the Constitution. He learned about a process called informa pauperis, a Latin term meaning in the manner of a pauper. It allows a person without any money to file a petition directly with the Supreme Court of the United States. And so, with a pencil and a stack of prison-issued stationery, Clarence Gideon, the 5th grade dropout, sat down and wrote to the 9 most powerful judges in the country. His petition was written in the simple, earnest language of a layman. He wasn't trying to sound like a lawyer. He was just telling his story. He explained that he had been denied a lawyer, forced to defend himself, and as a result was now serving 5 years for a crime he didn't commit. He argued that it was impossible to have a fair trial without a lawyer, and that the state of Florida had violated his constitutional rights under the 6th and 14th Amendments. He mailed it off, a single handwritten plea against the entire weight of the American legal establishment. Every year, the Supreme Court receives thousands of these petitions from prisoners. Almost all of them are dismissed. They are often rambling, incoherent, or legally baseless. But there was something about Gideon's letter. Something in its clarity, its simplicity, its profound sense of injustice. The clerks who read it flagged it. The justices read it. And against all odds they agreed. They would hear his case. The Supreme Court then did something remarkable. They appointed one of the most brilliant and respected lawyers in Washington, D.C. to argue on Gideon's behalf, a man named Abe Fortas, who would himself later become a Supreme Court justice. Suddenly, Clarence Gideon, the penniless prisoner in Florida, had one of the best legal minds in the nation fighting for him for free. The case, Gideon v. Wainwright, was argued in January 1963. Fortas stood before the Supreme Court and made a powerful argument. He said that the law is a complex maze. To expect an ordinary person, without any training, to navigate it successfully against a professional prosecutor is to make a mockery of a fair trial. The prosecutor, he argued, is a professional fighter. Sending a man into the ring against him without a lawyer is like sending a lamb to the slaughter. Justice, he declared, cannot depend on how much money a person has. On March 18, 1963, the Supreme Court issued its decision. It was unanimous, 9-0 in favor of Clarence Gideon. Writing for the court, Justice Hugo Black delivered one of the most famous lines in legal history. Reason and reflection require us to recognize that in our adversary system of criminal justice, any person haled into court, who is too poor to hire a lawyer, cannot be assured a fair trial unless counsel is provided for him. He went on to say that lawyers in criminal courts are necessities, not luxuries. The impact was immediate and monumental. The ruling didn't just apply to Gideon. It applied to every state, every court, every poor defendant in America. Overnight, the very foundation of the criminal justice system shifted. Thousands of prisoners across the country who had been convicted without lawyers were suddenly entitled to new trials. States scrambled to create and fund public defender offices to meet the new constitutional requirement. The right to a court-appointed attorney, something we now take for granted and hear in every cop show, was born from this single case. And what about Clarence Earl Gideon? The state of Florida had to give him a new trial. This time he had a lawyer, a skilled local public defender. And that lawyer did what Gideon couldn't. He investigated the case. He found new witnesses. And during the trial, he absolutely destroyed the credibility of the prosecution's star witness, revealing that it was far more likely the witness himself who had committed the crime. After just 1 hour of deliberation, the new jury came back. The verdict: not guilty. Clarence Earl Gideon walked out of the courthouse a free man. He had not only won his own freedom, but had fundamentally reshaped the meaning of justice for millions of people he would never meet. His stubborn faith in the promise of the Constitution, scrawled on a piece of prison paper, proved that sometimes the most powerful voice in the land isn't a politician or a judge, but an ordinary citizen demanding that the system live up to its own ideals. It's a powerful reminder that justice isn't just about punishing the guilty. It's about protecting the innocent, no matter who they are or how much money they have in their pocket. But this expansion of rights for the accused was just one piece of a much larger, more turbulent puzzle America was facing. At the very same time, an even more profound battle was being waged, not in the courtrooms of petty crime, but in the classrooms of the nation's children. The year was 1896. The Supreme Court had delivered a verdict that would cast a long dark shadow over the nation for more than half a century. In a case called Plessy v. Ferguson, the court established a devastating legal doctrine: separate but equal. It was a lie, of course, a convenient fiction that gave the stamp of federal approval to racial segregation. It meant that states could legally separate black and white Americans in virtually every aspect of public life, on trains, in parks, in restaurants, as long as the separate facilities were, in theory, equal. In practice, they never were. And nowhere was this inequality more stark, more damaging than in the schools. Across the South, and in many other parts of the country, this meant two entirely different worlds of education. For white children, there were new brick buildings with up-to-date textbooks, proper heating, and enough seats for everyone. For black children, the reality was often a one-room, dilapidated wooden shack with tattered hand-me-down books, a wood stove for heat, and not nearly enough resources for a real education. This wasn't just an injustice. It was a system designed to crush potential before it could ever take root. It was a message, sent from the earliest age, that some children were worth less than others. For decades, this was the law of the land. But by the early 1950s, a legal storm was gathering, and at its center was a little girl in Topeka, Kansas. Her name was Linda Brown. She was in the 3rd grade. Every morning, she had to walk 6 blocks, through a dangerous railroad switching yard, to catch a bus that would take her to the all-black Monroe Elementary School, over a mile away. It was a long, cold, and often frightening journey for a child. But what made it truly absurd, truly insulting, was that just 7 blocks from her home stood the Sumner School, a modern, clean, whites-only elementary school. Her father, Oliver Brown, tried to enroll her there. He was, of course, turned away. He wasn't just a frustrated parent. He was now a plaintiff. The local chapter of the NAACP had been waiting for a family like the Browns to challenge the system, and they had a legal titan on their side. A brilliant, tireless lawyer named Thurgood Marshall. Marshall wasn't just fighting one case in Kansas. He was the chief counsel for the NAACP Legal Defense Fund, and he was playing chess on a national scale. The case we know as Brown versus the Board of Education wasn't just about Linda Brown. It was actually a consolidation of 5 separate lawsuits from Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., all strategically brought together to strike at the very heart of segregation. Marshall's argument was revolutionary. For 50 years, opponents of segregation had tried to prove that separate facilities were not, in fact, equal. They would measure classroom sizes, count books, and compare teacher salaries, trying to chip away at the lie. But Marshall and his team went for the jugular. They argued something far more profound. They argued that even if the schools were perfectly equal in every measurable way, if they had the same books, the same funding, the same buildings, the very act of separating children on the basis of race was inherently unequal. To prove it, they brought in evidence that had never been used in the Supreme Court before: social science. They presented the groundbreaking work of psychologists Kenneth and Mamie Clark, the famous doll tests. In these studies, black children were presented with two dolls, identical in every way except for their skin color. They were then asked a series of questions. Show me the doll you like to play with. Show me the doll that is the nice doll. Show me the doll that is the bad doll. And finally, show me the doll that looks like you. The results were heartbreaking. Overwhelmingly, the children preferred the white doll. They described the black doll as bad and ugly. Some of them even cried when they had to admit that the bad doll was the one that looked like them. It was devastating, irrefutable proof of the deep psychological damage that segregation inflicted. It wasn't about buildings or books. It was about branding an entire race of children with a stamp of inferiority, creating a wound that could last a lifetime. The case was argued before the Supreme Court in 1952, but the justices were deeply divided. They couldn't reach a decision. They scheduled it to be re-argued the following year. In that time, a crucial change happened. The Chief Justice died and President Eisenhower appointed a new one, Earl Warren, the former governor of California. Warren saw immediately that this was more than just a legal case. It was a moral reckoning for America. He believed that for such a monumental decision to have any real authority, it couldn't be a narrow 5-4 split. It had to be unanimous. He spent months working behind the scenes, persuading, cajoling, and appealing to his fellow justices' sense of history and justice. On May 17, 1954, the waiting was over. Chief Justice Earl Warren began to read the court's opinion. The room was silent. And then he delivered the words that would change America forever. We come then to the question presented. Does segregation of children in public schools solely on the basis of race deprive the children of the minority group of equal educational opportunities? We believe that it does. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. It was a legal earthquake. With that single sentence, 60 years of American law was wiped away. The legal foundation for the entire Jim Crow system of segregation had been shattered. But a Supreme Court decision is just words on paper. Enforcing it is another matter entirely. The reaction in the South was swift and furious. Over 100 Southern congressmen signed the Southern Manifesto, denouncing the ruling and pledging massive resistance. Schools were shut down, funds were cut, and state-sponsored racism became more defiant than ever. The ultimate test came in 1957 in Little Rock, Arkansas. 9 black students, who would become known as the Little Rock Nine, attempted to enroll in the all-white Central High School. They were met by the governor of Arkansas, Orville Faubus, who had called in the Arkansas National Guard to physically block them from entering. They were surrounded by a screaming, hateful mob. The standoff became a national crisis, broadcast on televisions around the world. Finally, President Dwight D. Eisenhower, who had been reluctant to enforce the ruling, was forced to act. He sent in the 101st Airborne Division of the United States Army to escort those 9 brave teenagers into that school. Brown v. Board of Education didn't end segregation overnight. The fight would take decades, and in many ways it continues to this day. But its importance cannot be overstated. It was the crucial first domino. It provided the legal and moral firepower for the entire civil rights movement. It was the precedent that allowed for the dismantling of segregation in every other part of American life. It fundamentally rewrote the promise of the 14th Amendment's guarantee of equal protection under the laws. The battle for equality in the public square was now in full force, a fight for the very soul of the nation. But at the same time, another, quieter revolution was beginning. A revolution not about what the government could do to you in public, but what it could say about what you did in private behind the closed doors of your own home. It was a question that felt almost medieval, a relic from a bygone era. In the state of Connecticut in the early 1960s, a law passed in 1879, the Comstock Law, was still on the books. And it was one of the most invasive, most personal laws imaginable. It made it a crime to use any drug, medicinal article or instrument for the purpose of preventing conception. Not just selling them, using them. Think about that for a moment. The state of Connecticut was claiming the authority to regulate what a husband and wife did in the privacy of their own bedroom. For decades, the law was rarely enforced, existing as a strange, silent threat. But its very existence had a chilling effect. Doctors were afraid to give married couples advice on family planning. Couples were denied access to modern, safe methods of contraception. It was a law that turned a deeply personal decision into a potential state crime. And for two people, a doctor and an activist, this was not just an inconvenience. It was an intolerable assault on human dignity. Their names were Estelle Griswold and Dr. C. Lee Buxton. Griswold was the executive director of the Planned Parenthood League of Connecticut. Dr. Buxton was a physician and professor at the Yale School of Medicine. They weren't accidental lawbreakers. They were strategic rebels. They knew the only way to kill this archaic law was to force a confrontation. So, on November 1, 1961, they did something incredibly brave and deliberately illegal. They opened a birth control clinic in New Haven, Connecticut. Their goal wasn't to operate in the shadows. It was to be seen, to be caught. They provided information and medical advice on contraception to married couples, documenting everything. As expected, it didn't take long. Just 10 days after opening, the police arrived. Griswold and Buxton were arrested, tried, and found guilty. Their punishment? A fine of $100 each. $100. Seems like nothing. A slap on the wrist. But for Griswold and Buxton, that $100 fine was their golden ticket. It was the price of admission to the United States Supreme Court. They appealed their convictions through the Connecticut courts, which stubbornly upheld the old law. But they kept pushing because their fight was never about the $100. It was about a fundamental question that the Constitution didn't seem to answer directly. Do Americans have a right to privacy? When the case, Griswold v. Connecticut, finally reached the Supreme Court in 1965, the justices were faced with a puzzle. Go ahead, read the Bill of Rights. You won't find the word privacy anywhere in it. The government of Connecticut argued its case simply. The law was passed by the legislature. It's our right as a state to regulate health, safety, and morals. If the people of Connecticut don't like the law, they can elect new representatives to repeal it. The courts, they argued, have no business inventing a new constitutional right out of thin air, just because they think a law is silly or outdated. It was a powerful argument based on judicial restraint. And for some justices like Hugo Black and Potter Stewart, it was convincing. They would later dissent, with Stewart famously writing that the law was, in his opinion, an uncommonly silly law. But it wasn't the court's job to strike down laws just because they're silly. But for the majority of the court, led by Justice William O. Douglas, the idea that the government could reach into the marital bedroom was horrifying. It went against the very grain of American liberty. The problem was finding the legal justification to stop it. And this is where Justice Douglas got creative, introducing one of the most famous and controversial concepts in Supreme Court history. He argued that a right to privacy does exist in the Constitution, not in a single line but in the shadows. He called these shadows penumbras. A penumbra is an astronomical term for the partial shadow on the edges of a total eclipse. Douglas argued that the specific rights listed in the Bill of Rights have penumbras, formed by emanations from those guarantees that help give them life and substance. It was a poetic, almost mystical way of saying that the individual rights we do have create a larger implied zone of privacy. Let's break that down. The First Amendment protects freedom of speech and association. This creates a zone of privacy for our thoughts and personal relationships. The Third Amendment prevents the government from forcing you to quarter soldiers in your home. This creates a zone of privacy in your house. The Fourth Amendment protects you from unreasonable searches and seizures. Another clear zone of privacy. The Fifth Amendment protects your right to remain silent, protecting the privacy of your own mind. Douglas argued that you can't just look at these rights in isolation. You have to see what they add up to. Together, he wrote, these various guarantees create zones of privacy. And the most sacred, most private zone of all? The marital relationship. The decision to have children or not to have children was a decision that belonged to the couple, not the state. The government, he argued, had no place in the bedrooms of the nation. On June 7, 1965, the court handed down its 7-2 decision. The Connecticut law was unconstitutional. Estelle Griswold and Dr. Buxton had won. But they had done more than just legalize contraception for married couples. They had fundamentally changed the relationship between the American citizen and the state. The Supreme Court had officially recognized, for the very first time, a constitutional right to privacy. The impact of this decision is almost impossible to overstate. It was a legal earthquake that sent shockwaves through American society for decades to come. Initially, the ruling was narrow. It applied specifically to the privacy of married couples. But the door once opened could not be closed. In 1972, the court extended this right to unmarried people in Eisenstadt v. Baird. And then, just 1 year later in 1973, the right to privacy established in Griswold became the direct legal foundation for the single most controversial Supreme Court decision of the 20th century, Roe v. Wade. The court reasoned that the right of personal privacy was broad enough to encompass a woman's decision whether or not to terminate her pregnancy. Without the quiet battle over a $100 fine in Connecticut, Roe might never have happened. The legacy of Griswold continues to this day. It was cited in the 2003 case Lawrence v. Texas, which struck down laws criminalizing same-sex intimacy, affirming a right to privacy in personal relationships. And it was part of the legal underpinning for the 2015 decision in Obergefell v. Hodges, which legalized same-sex marriage nationwide. It all started with a simple defiant act: opening a clinic. It was a case born not from a violent crime or a massive corporate dispute, but from the quiet, intimate question of who gets to decide what happens in a family. By finding a right to privacy in the penumbras of the Constitution, the Supreme Court didn't just strike down an old law. It armed citizens with a new shield against government intrusion. It was a shield that would be tested again and again, in battles over sex, life, and death. And it drew a new, profound line in the sand, separating the public power of the state from the private life of the individual. But as America hurtled through the turbulent 1960s, the courts would soon be forced to confront a different kind of line, one that had divided the country not in its bedrooms, but in its schools, its buses, and its lunch counters for over a century. The line of color. That line of color was etched into the very soul of American law by a single insidious phrase: separate but equal. It was the ghost of a decision from 1896, a case called Plessy v. Ferguson, which had declared that racial segregation was perfectly constitutional, as long as the separate facilities for Black and white Americans were equal. But in reality, they never were. Separate always meant dilapidated, underfunded, and inferior for Black Americans. It meant hand-me-down textbooks, crumbling schoolhouses, and a constant crushing message of second-class citizenship. For over half a century, this legal fiction was the bedrock of Jim Crow, a system designed to maintain a racial hierarchy that the Civil War was supposed to have abolished. And it was in the heart of this system, in Topeka, Kansas in 1951, that a third grader named Linda Brown became the face of the challenge that would finally tear it down. Linda's story was brutally, painfully simple. There was a good school, Sumner Elementary, just 7 blocks from her home. But Sumner was an all-white school. By law, Linda was forced to walk 6 blocks to a bus stop, often in freezing weather, to be driven a mile away to the all-black Monroe Elementary. Her father, Oliver Brown, was a welder and a pastor. He wasn't a radical activist. He was just a father who looked at the injustice his daughter faced every single day, and decided it was wrong. He tried to enroll Linda at Sumner Elementary, and when she was inevitably denied, he joined a class action lawsuit filed by the NAACP. His name was listed first, and so the case that would change America became known as Oliver Brown et al. v. the Board of Education of Topeka. But this wasn't just about Topeka. The NAACP had been meticulously planning this assault for years, filing similar lawsuits in South Carolina, Virginia, Delaware, and Washington, D.C. They consolidated these cases, aiming not just to chip away at the edges of segregation, but to strike at its very heart. And the man leading this legal crusade was a figure of towering intellect and unshakable resolve, Thurgood Marshall. Marshall was more than a lawyer. He was a force of nature. He had seen the ugliness of Jim Crow firsthand. He had been denied entry to the University of Maryland Law School because of his race, forcing him to attend Howard University instead. He had traveled through the segregated South, often at great personal risk, defending Black clients and building the legal framework to dismantle the system that oppressed them. Marshall understood that to win, he couldn't just argue about unequal facilities, leaky roofs, and outdated textbooks. That was the old strategy, and it only ever resulted in small, localized victories. His new strategy was audacious. He would argue that the very act of separation was a brand of inequality. He would put segregation itself on trial. To do this, Marshall and his team brought in a new kind of evidence, something the Supreme Court had rarely seen before: psychological research. They presented the groundbreaking work of two psychologists, Drs. Kenneth and Mamie Clark. The Clarks had conducted a series of now famous experiments known as the doll tests. They presented young black children with two dolls, one white and one black, and asked them a series of questions. Show me the doll that you like to play with. Show me the doll that is the nice doll. Show me the doll that looks bad. Overwhelmingly, the children, regardless of their own skin color, attributed the positive characteristics to the white doll and the negative ones to the black doll. When asked to pick the doll that looked like them, some of the children would cry or run out of the room. This was Marshall's masterstroke. The doll tests were devastating, empirical proof of the psychological damage that segregation inflicted. It wasn't about buildings or budgets. It was about the hearts and minds of children. Marshall argued before the 9 justices of the Supreme Court that a system that teaches a child that they are inherently inferior because of the color of their skin can never be equal. It stamps them with the badge of inferiority that affects their motivation, their ability to learn, and their place in the world. He was asking the court to look past the letter of the law in Plessy and see the human cost of its legacy. The court was deeply divided. The justices knew that overturning a 58-year-old precedent would unleash a political firestorm. The arguments were heard in 1952, but the court couldn't reach a decision and asked the lawyers to re-argue the case the following year. In the interim, a crucial event occurred. The Chief Justice, Fred Vinson, who was skeptical of overturning Plessy, died suddenly of a heart attack. President Eisenhower replaced him with Earl Warren, the former governor of California. It was a decision Eisenhower would later call the biggest damn fool mistake I ever made. Warren was not considered a legal scholar, but he possessed a deep sense of justice and formidable political skill. He understood that in a case this monumental, a split 5-4 or 6-3 decision would be seen as weak and illegitimate, especially in the South. It would invite defiance. He needed unanimity. For months he worked behind the scenes, not through complex legal arguments, but through appeals to morality and justice. He delayed votes, held informal conversations, and patiently persuaded the remaining holdouts, arguing that the only way for the court to maintain its moral authority was to speak with a single unified voice. On May 17, 1954, Chief Justice Earl Warren read the unanimous opinion of the court. He kept the language simple, direct, and free of legal jargon, so that any American could understand it. He laid out the history of the 14th Amendment and acknowledged that education was different now than it was in the 1860s. Then, he delivered the fatal blow to segregation. We come then to the question presented. Does segregation of children in public schools solely on the basis of race deprive the children of the minority group of equal educational opportunities? We believe that it does. And then came the 9 words that echoed across the nation. Separate educational facilities are inherently unequal. The Plessy v. Ferguson doctrine was dead. Legal segregation in American schools was now unconstitutional. It was a seismic victory, a legal earthquake that shattered the foundation of Jim Crow. But a court ruling is just words on paper. The decision didn't provide a roadmap for how to desegregate. Instead, in a follow-up ruling, it famously ordered states to proceed with all deliberate speed. A phrase so ambiguous it became an open invitation for delay and defiance. What followed was not a smooth transition to integrated harmony, but a period of massive resistance. Southern politicians passed laws to block desegregation. White citizens' councils formed to intimidate black families. The Ku Klux Klan was re-energized. The battle for America's soul moved from the courtroom to the schoolhouse steps. In 1957, 9 black teenagers, the Little Rock Nine, had to be escorted by federal troops into Central High School in Arkansas against the orders of the governor. The images of angry, screaming mobs harassing these brave students were broadcast around the world, exposing the raw, violent hatred that underpinned the separate but equal lie. Brown v. Board of Education didn't end racism, nor did it magically integrate America overnight. But it changed the country's legal and moral compass. It established a new principle, that the Constitution is colorblind. It gave the civil rights movement an unimpeachable legal foundation and moral high ground from which to launch the next phase of its fight. The case revealed a profound truth. Winning in the Supreme Court is one thing, but enforcing that victory in the streets, in the legislatures, and in the hearts of the people is another battle entirely. The fight for equality had won its most important legal victory, but it also exposed the deep, dark chasm between what the law promised and what reality delivered. This created a new urgent question. If the government can't or won't protect the rights the court has just affirmed, who will? And what happens when an individual stripped of their rights faces the full, overwhelming power of the state alone? That question would be answered not by a president, a protest, or a new law from Congress, but by one of the unluckiest men in America. A man who, in 1961, seemed to have nothing left to lose. His name was Clarence Earl Gideon. He was a 51-year-old drifter with an 8th grade education and a long, sad history of petty crimes. He wasn't a monster or a mastermind. He was just a man who had spent much of his life on the wrong side of the law and the wrong side of luck. In June of that year, someone broke into the Bay Harbor pool room in Panama City, Florida. They smashed a jukebox, stole some wine and beer, and swiped a handful of change from the cash register. It was a minor, forgettable crime. A witness told police he'd seen Gideon inside the pool hall early that morning. That was enough. Gideon was arrested and charged with breaking and entering with intent to commit a misdemeanor. When his day in court arrived, Clarence Gideon stood before the judge, a poor man with no one in his corner. He knew he was innocent of this particular crime, and he also knew he was in serious trouble. He looked at the judge and made a simple, direct request. "Your Honor, I request this court to appoint counsel to represent me in this trial." The judge's reply would echo all the way to the Supreme Court. He said, "Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case. Under the laws of the state of Florida, the only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense." A capital offense? A crime punishable by death. For anything less, you were on your own. Imagine that moment. The full weight of the state of Florida, its investigators, its experienced prosecutor, its legal machinery, was aimed squarely at this one solitary man. And he was being told to defend himself. Gideon, who had never finished middle school, was now expected to act as his own lawyer. He had to select a jury, cross-examine witnesses, raise objections, and deliver a closing argument. It was a farce. He tried his best, but he was hopelessly outmatched. He questioned the witness who accused him, but he didn't know how to impeach his credibility. He gave a rambling, heartfelt closing statement, but it was legally meaningless. The prosecutor, by contrast, was a professional. He ran circles around Gideon. The jury, perhaps unsurprisingly, found him guilty. The judge sentenced him to 5 years in the state prison. 5 years. For a crime he maintained he didn't commit, after a trial that was fundamentally unfair. In his prison cell, most men would have surrendered to despair. But Clarence Gideon possessed a stubborn, unshakable belief in justice. He spent his days in the prison library, poring over law books, teaching himself the language of the courts. He learned about the Constitution, about his rights, and about a legal tool called a writ of habeas corpus, a way to challenge an unlawful imprisonment. And then, he did something extraordinary. With a pencil on lined prison stationery, this forgotten man in a Florida prison wrote a petition to the most powerful court in the land, the Supreme Court of the United States. In his simple, sometimes misspelled handwriting, he laid out his case. He argued that it was impossible to have a fair trial without a lawyer, and that the United States Constitution guaranteed him one. He mailed his humble petition, and it joined a mountain of other long-shot appeals from prisoners across the country. But Gideon's petition was different. It asked a question so fundamental, so critical to the very idea of American justice, that the 9 justices couldn't ignore it. The question was this: does the 6th Amendment's guarantee of a right to counsel apply to defendants in state courts? The Bill of Rights originally only applied to the federal government. But the 14th Amendment, passed after the Civil War, said that no state could deprive any person of life, liberty, or property without due process of law. So, was having a lawyer part of due process? Was it essential for a fair trial? Or was it a luxury, something states were free to grant or deny as they saw fit? The Supreme Court agreed to hear the case. Gideon v. Wainwright. They appointed one of Washington, D.C.'s most brilliant and respected attorneys, Abe Fortas, a future Supreme Court justice himself, to argue on Gideon's behalf. The stage was now set for a legal showdown that would redefine justice in America. In the courtroom, Fortas's argument was powerful and clear. He painted a vivid picture of the imbalance of power that Gideon had faced. On one side, he said, you have the state with its paid prosecutor, its investigators, its resources, and its expertise. On the other side, you have the accused, often poor, uneducated, and terrified. To expect that person to defend themselves against the state's machinery, Fortas argued, is not a trial, it's a spectacle. He famously declared, "I cannot believe that this court will ever say that a man who is too poor to hire a lawyer can be forced to trial without a lawyer." On March 18, 1963, the Supreme Court delivered its answer. In a unanimous 9-0 decision, they sided with Clarence Gideon. Writing for the court, Justice Hugo Black penned words that would become legendary. He wrote that in our justice system, any person hailed into court who is too poor to hire a lawyer cannot be assured a fair trial unless counsel is provided for him. He concluded that the noble ideal of fair trials cannot be realized if the poor man has to face his accusers alone. It was a landmark victory for the rights of the individual against the overwhelming power of the state. The story, however, doesn't end there. The Supreme Court's ruling didn't set Gideon free. It just said his original trial was unconstitutional. It ordered that he be given a new trial, this time with a lawyer. So Clarence Gideon went back to that same Florida courtroom. But this time he wasn't alone. He had a skilled local defense attorney who meticulously dismantled the prosecution's case. He showed that the state's key witness was likely the one who had actually committed the burglary. He exposed inconsistencies and offered a compelling alternative theory. After the closing arguments, the jury went to deliberate. They were back in less than an hour. The verdict? Not guilty. Clarence Earl Gideon, the man who had changed the American legal system with a pencil, was finally a free man. The impact of Gideon v. Wainwright was immediate and immense. It was like a legal earthquake. All across the country, thousands of inmates who had been convicted without a lawyer were now entitled to new trials. States were forced to create and fund public defender systems to provide legal representation for anyone who couldn't afford it. The ruling established a fundamental principle: that the quality of justice you receive should not depend on the amount of money in your pocket. It affirmed that when you face the power of the state, you do not have to stand alone. Gideon provided an answer to the question of what happens in the courtroom, but it also raised another, equally pressing question. The right to a lawyer is crucial during a trial, but what about before the trial? What about in the moments after an arrest? In the small windowless interrogation room, under the glare of a single light bulb, where the pressure to confess is immense, what rights does a person have then, when they are at their most vulnerable, isolated, and alone with the authorities? This question, the one that hangs in the air of every police station in America, was answered by a man who was, by all accounts, a nobody. A drifter. A ninth-grade dropout with a long rap sheet for petty crimes. His name was Ernesto Miranda, and in 1963, in Phoenix, Arizona, he was accused of something far from petty. A young woman had been kidnapped and brutally raped. A week later, her brother spotted a car he thought was the attacker's. The car was traced to Ernesto Miranda. He was brought in, placed in a lineup, and identified by the victim. What happened next is the crux of the entire story. Miranda was taken into an interrogation room. For 2 hours, 2 detectives questioned him. There were no threats. No one laid a hand on him. They didn't shine a bright light in his eyes or deprive him of sleep. By the standards of the day, it was a professional, by-the-book interrogation. And at the end of it, Ernesto Miranda didn't just confess to the crime. He wrote his confession down by hand, on a piece of paper with a pre-printed paragraph at the top. It read, "I do hereby swear that I make this statement voluntarily and of my own free will, with no threats, coercion, or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me." He signed it. Case closed. Or so it seemed. At his trial, that signed confession was the star witness for the prosecution. It was everything they needed. His own court-appointed lawyer argued that the confession shouldn't be allowed. How could it be voluntary? Miranda was poor, uneducated, and likely had mental issues. He was never told he had a right to a lawyer. He was never told he had the right to stay quiet. He didn't have full knowledge of his legal rights, because no one ever told him what they were. The judge disagreed. The jury found him guilty. He was sentenced to 20 to 30 years in prison. For most people, that would have been the end. Another conviction, another forgotten man in a cell. But Miranda's case was taken up by a determined lawyer from the American Civil Liberties Union, who saw something bigger at play. This wasn't just about one man's confession. It was about a fundamental imbalance of power. It was about what the Fifth Amendment's protection against self-incrimination truly means. Does it only protect you from being tortured into a confession? Or does it also protect you from the immense, unseen psychological pressure of being alone, in a room with armed authorities who are trained to get you to talk? The case climbed the legal ladder, from Arizona's courts all the way to the highest court in the land, the Supreme Court of the United States. In 1966, the Supreme Court took up Miranda v. Arizona, bundling it with 3 other similar cases. The nation's legal community was divided. On one side, law enforcement argued that confessions were an essential tool for solving crimes. If you had to tell every suspect they could have a lawyer and stay silent, no one would ever confess again. Criminals would walk free. On the other side, civil libertarians argued that a confession obtained from someone who doesn't know their rights is no confession at all. It's a product of ignorance and intimidation, a violation of the very principles of American justice. The court had to decide what happens in that closed room. Chief Justice Earl Warren, writing for a narrow 5-4 majority, delivered an opinion that would echo through American history. He acknowledged the power of psychological coercion. He wrote that the interrogation environment carries its own badge of intimidation. To combat this, he said the system needed safeguards. Not suggestions, not guidelines, but clear, unambiguous, mandatory warnings that must be given to a person before any custodial interrogation. And so, the Miranda rights were born. You know them. You've heard them 1,000 times in movies and on TV. You have the right to remain silent. This directly invokes the Fifth Amendment. The government cannot force you to be a witness against yourself. Anything you say can and will be used against you in a court of law. This is the consequence. It makes the stakes crystal clear. Your words are weapons that can be turned against you. You have the right to an attorney. This brings in the Sixth Amendment's right to counsel, which the court had recently affirmed in Gideon v. Wainwright. But Miranda took it a step further. You don't just have a right to a lawyer at trial. You have a right to have one with you during the interrogation itself, when you are most vulnerable. And finally, the great equalizer. If you cannot afford an attorney, one will be appointed for you. This ensured that justice wasn't just for the wealthy. Your rights didn't depend on the size of your bank account. This ruling was a seismic shock to American law enforcement. It fundamentally changed the way police did their jobs overnight. It shifted the balance of power in the interrogation room. No longer was a suspect an isolated individual at the mercy of the state. Now, they were an individual with clearly stated, constitutionally protected rights. The decision was incredibly controversial. Critics called it handcuffing the police and predicted a crime wave. But the ruling stood, becoming so deeply woven into the fabric of American culture that it's now simply known by the name of the man who started it all. But what about that man, Ernesto Miranda? The Supreme Court's decision didn't set him free. It simply threw out his confession. His case was sent back to Arizona for a new trial. This time, the prosecution couldn't use his signed statement. But that didn't matter. They had another witness, Miranda's common-law wife, who he had confessed to when he got home from the police station. She testified against him. In 1967, Ernesto Miranda was convicted of kidnapping and rape for a second time and sent back to prison. He was paroled in 1972. He tried to make a living by selling autographed Miranda warning cards for $1.50 apiece. A strange, sad footnote to a case that changed the nation. But his story has one final, brutal twist of irony. 4 years later, in 1976, Ernesto Miranda was back in a dingy Phoenix bar. An argument over a $3 poker pot escalated into a fight. Miranda was stabbed. He staggered outside and bled to death in the street. He was 34 years old. The police arrived on the scene, started their investigation, and soon, they had a suspect in custody. They took him down to the station, sat him in an interrogation room, and before they asked him a single question about the murder of Ernesto Miranda, the officer pulled out a card and began to read. "You have the right to remain silent." The suspect was read his Miranda rights. The rights named for the very man he was accused of killing. The Miranda case is a stark reminder that the grand principles of law are forged in the messy, often tragic, lives of real people. It established that our rights are not abstract ideas in a textbook. They must be actively protected, especially when we are at our weakest. But this raises another profound question. The rights of the accused are now enshrined. But what about the rights of the public as a whole? We've talked about the rights of an individual against the state in a criminal context. But what happens when an individual's right to, say, free speech directly clashes with the government's sworn duty to protect the nation itself? especially in the crucible of war. What happens when speaking your mind is seen as an act of treason? That question hung heavy in the air in 1917. America, a nation that had desperately tried to remain neutral, was finally dragged into the inferno of World War I. And with that entry came a tidal wave of patriotism, unlike anything the country had ever seen. But beneath that wave was a dangerous undercurrent: fear. Fear of spies, fear of saboteurs, and most of all fear of dissent. To fight the war over there, the government felt it needed absolute unity over here. And so, Congress passed the Espionage Act of 1917. It sounds like a law aimed at spies, and it was, but it contained a provision that was far broader, making it a crime to willfully cause or attempt to cause insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States. In short, it became a federal crime to do anything that might discourage a man from fighting. This is where we meet Charles Schenck. Schenck was not a spy. He was the General Secretary of the Socialist Party in Philadelphia. He and his fellow socialists saw World War I not as a noble crusade for democracy, but as a monstrous capitalist meat grinder, where poor men from one country were sent to kill poor men from another for the profit of the rich. And when the United States passed the Selective Service Act, instituting a mandatory military draft, Schenck saw it as the ultimate betrayal of American freedom. So, he did what political activists do: he protested. He and his associate, Elizabeth Bear, printed and mailed over 15,000 leaflets to men who had been drafted. Now, these pamphlets were not a call to violent revolution. They didn't tell men to burn their draft cards or attack recruitment centers. Instead, they made a passionate, constitutional argument. They argued that the draft was a form of involuntary servitude, directly violating the 13th Amendment, the very amendment that had abolished slavery. One side of the leaflet declared, in bold letters, "Assert your rights." It called the draft despotism in its worst form, and a monstrous wrong against humanity. It urged the draftees not to submit to intimidation but to petition for the repeal of the Draft Act. It was a powerful piece of political speech, aimed directly at the people most affected by the government's policy. To the Wilson administration, this was not speech. This was sabotage. Schenck and Bear were promptly arrested and charged with violating the Espionage Act. The government's case was simple. By telling draftees the draft was unconstitutional, and that they should assert their rights, Schenck was directly attempting to obstruct the draft. He was weakening America's ability to fight a war, and in the government's eyes, that was a threat to the nation's very survival. Schenck's defense was just as simple: the First Amendment. Congress shall make no law abridging the freedom of speech. He argued that he was doing nothing more than what political dissenters had done since the founding of the Republic, criticizing a government policy he believed was wrong and unjust. He hadn't used threats or incited violence. He had used words, ideas, and constitutional arguments. If that wasn't protected speech, what was? The jury didn't agree. Schenck was found guilty. He appealed, but his conviction was upheld. His last hope was the Supreme Court. In 1919, the case of Schenck v. United States landed before the 9 justices, presenting them with one of the most fundamental questions they could ever face. Is freedom of speech absolute? Or can the government limit what we say when the nation's security is on the line? The opinion for the unanimous court was written by one of the most legendary figures in American law. Justice Oliver Wendell Holmes Jr. Holmes was no stranger to the costs of war. He was a thrice-wounded veteran of the Civil War. And in his decision, he forged a concept that would define the limits of free speech for the next 50 years. He upheld Schenck's conviction. The First Amendment, he wrote, does not provide absolute protection for every utterance. In a passage that has echoed through courtrooms ever since, he explained, the character of every act depends upon the circumstances in which it is done. The most stringent protection of free speech would not protect a man in falsely shouting fire in a theater and causing a panic. Let's pause on that because it is one of the most brilliant and enduring legal analogies ever conceived. What does it mean? Shouting the word fire is just speech. But shouting it in a crowded theater where there is no fire is not just an idea. It is an act. It's an act that is almost certain to cause immediate, tangible harm. People will be trampled, injured, perhaps even killed in the stampede. The speech itself becomes the trigger for chaos. Holmes then applied this logic to Charles Schenck. In ordinary times, he argued, Schenck's pamphlets might have been perfectly legal. But these were not ordinary times. It was 1917. The country was at war. Mailing thousands of pamphlets to draftees, Telling them the draft was a crime and that they should resist it was, in Holmes's view, the equivalent of shouting fire in a crowded theater. It created a clear and present danger of bringing about the substantive evils that Congress had a right to prevent, namely, a successful military draft and the ability to wage war. The words weren't just abstract political theory. They were, as Holmes put it, a spark that could ignite a devastating fire. The clear and present danger test was born, and with it, the Supreme Court gave the government a powerful legal weapon. For the first time, there was a standard for punishing speech. If the government could prove that a person's words created a clear and present danger of a significant evil, that speech could be legally suppressed, and the speaker could be sent to prison. In the years that followed, this test was used to convict hundreds of anti-war protesters, socialists, and anarchists. It became a tool to enforce conformity during times of national crisis. But the story doesn't quite end there, because the creator of the test, Justice Holmes himself, soon began to have second thoughts. Just months after the Schenck decision, in another case involving anti-war protesters, Holmes found himself in dissent. He saw how broadly the clear and present danger test was being applied to crush any and all dissent, and he began to pull back. He argued for a more protective view of speech, introducing another iconic idea: the marketplace of ideas. The best test of truth, he wrote, is the power of a thought to get itself accepted in the competition of the market. He argued that unless speech imminently threatens to overthrow the government, it should be allowed, so that society can debate and choose the best ideas. This evolution is critical. Schenck established that speech has limits, but the debate it started is one that has never ended. The clear and present danger test itself was eventually replaced in 1969 by an even stricter, more speech-protective standard, which holds that the government can only punish speech that is directed to inciting imminent lawless action, and is likely to produce such action. But the ghost of Schenck remains. Every time we argue about whether a protest crosses the line from speech to incitement, every time we debate the regulation of hate speech that could lead to violence, every time we discuss the consequences of spreading dangerous disinformation during a public health crisis, we are wrestling with the question Justice Holmes first framed over a century ago. Where is the line between an idea and an action? At what point do words stop being just words and become a weapon? The case of Charles Schenck established that the government could, under certain circumstances, punish you for what you say. It carved out the first major exception to the First Amendment, an exception made in the crucible of war. But in its pursuit of people like Schenck, the government sometimes pushed the boundaries of its own power, not just in limiting speech, but in how it went about securing a conviction. What happens when the government, in its quest for justice, ignores the rights of the very person it has accused? What happens when the process itself becomes the punishment? That question found its answer in the harsh, sun-baked streets of Phoenix, Arizona, in 1963. It began not with a grand constitutional debate, but with a brutal crime. A young woman, just 18 years old, was walking home from her late-night shift at a movie theater. A man pulled up beside her, forced her into his car, drove her out to the desert and assaulted her. He then drove her back and dropped her off near her home, warning her to keep quiet. The police had very few leads. The victim could only give a vague description of her attacker and his car. But a few days later, her brother spotted a vehicle that looked similar and reported the license plate. The car was traced to a 23-year-old man named Ernesto Miranda. Miranda was a drifter with a long rap sheet, a man who had been in and out of trouble with the law since he was in junior high. He was, to put it mildly, not a sympathetic character. When the police brought him in for questioning, they didn't have a slam dunk case. They had a car that looked like the one used in the crime, and a suspect who fit a general description. So they did what police did every single day in 1963. They put him in a small windowless interrogation room. For 2 hours, 2 detectives questioned him. There was no physical violence, no overt threats. But imagine the scene. You are alone. The door is closed. 2 authority figures are relentlessly questioning you. They tell you that you've been identified in a lineup, even though that wasn't entirely true. They are professionals trained in the art of psychological pressure. And in that room, Ernesto Miranda, a man with only an 8th grade education, did what countless people before him had done. He broke. He confessed. Not only did he confess to the crime against the young woman, but he also confessed to a separate robbery. The police, wanting to make sure the confession was ironclad, handed him a piece of paper. At the top, it had a typed paragraph stating that the confession was made voluntarily, without threats or promises of immunity, and with full knowledge of my legal rights, understanding any statement I make may be used against me. Ernesto Miranda signed that paper, and then wrote out his confession in his own hand. The case was closed. A tidy piece of police work. Except for one colossal problem. No one had ever actually told him what his legal rights were. At his trial, the confession was the star witness for the prosecution. His own words, signed and delivered, were presented to the jury as undeniable proof of guilt. His court-appointed lawyer, a 73-year-old man named Alvin Moore, knew the confession was damning. He argued passionately that it shouldn't be allowed. He told the judge that Miranda had been coerced, that his confession was not truly voluntary because he was never informed of his right to remain silent, or his right to have an attorney present during the interrogation. The judge overruled him. The jury convicted Miranda in less than an hour. He was sentenced to 20 to 30 years in prison. And for almost anyone else, that would have been the end of the story. Another criminal off the streets, another case file stamped closed. But Alvin Moore appealed the conviction to the Arizona Supreme Court, which sided with the trial judge. The confession was good. The conviction stood. Still, the case had attracted the attention of the American Civil Liberties Union. A prominent Phoenix lawyer named John P. Frank, who had once clerked for a Supreme Court justice, saw something much bigger at play. This wasn't just about Ernesto Miranda. It was about a fundamental imbalance of power that played out in thousands of interrogation rooms across the country every single day. He believed that the Fifth Amendment's protection against self-incrimination was being systematically violated before a suspect ever even saw a courtroom. He took the case pro bono all the way to the United States Supreme Court. The case, now known as Miranda v. Arizona, posed a simple but profound question. Does the Constitution follow you into the interrogation room? The arguments before the court were a clash of two starkly different visions of justice. The state of Arizona argued that police needed confessions to solve crimes. They claimed that informing suspects of their rights would cause them to clam up, allowing countless guilty criminals to walk free. It was a pragmatic argument about public safety, but John Frank and his team argued for a principle. They argued that the moment a person is taken into custody, the environment is inherently coercive. The state has all the power. The individual has none. Without being explicitly told they have a right to be silent and a right to a lawyer, any confession is tainted. It's not a fair fight. It's an ambush. They argued that the Fifth Amendment is not a technicality to be exploited by criminals. It is a fundamental shield to protect citizens from the immense power of the government. On June 13, 1966, the Supreme Court issued its decision. It was a narrow 5-4 vote, but its impact was a legal earthquake. Chief Justice Earl Warren, writing for the majority, declared that the prosecution could not use any statement from a defendant in custody unless it could prove that procedural safeguards had been used to secure the privilege against self-incrimination. And then he laid out exactly what those safeguards were. They have become so ingrained in our culture, so ubiquitous in film and television, that almost every American can recite them from memory. The person in custody must be warned prior to any questioning that he has the right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. These became known as the Miranda rights. The decision was explosive. Police departments, prosecutors, and politicians across the country were outraged. They called it a handcuffing of the police. They predicted a massive spike in crime as criminals, now armed with this knowledge, would simply refuse to cooperate. But the revolution was not that it created new rights. The right to remain silent and the right to an attorney were already in the Constitution. The revolution of Miranda was that it forced the state to inform you of those rights at the moment you needed them most. It was a transfer of knowledge and therefore a transfer of power from the state to the individual, right at the crucible of the justice system. And what became of the man at the center of it all? Ernesto Miranda's conviction was overturned by the Supreme Court, but that didn't mean he was free. The state of Arizona simply decided to try him again. This time they couldn't use his confession, but they had other evidence. His common-law wife testified against him, revealing that he had told her about the crime. Based on that and other evidence, Ernesto Miranda was convicted a second time and sent back to prison. He was eventually paroled in 1972. His life after prison was short and violent. 4 years later, in 1976, He was in a dive bar in downtown Phoenix when a fight broke out over a $3 card game. Ernesto Miranda was stabbed and bled to death on the barroom floor. The police arrived on the scene and quickly identified a suspect. They placed the man under arrest. And as they put the handcuffs on him, they pulled out a small, laminated card from their pocket and began to read, "You have the right to remain silent." The very rights that bore Ernesto Miranda's name, the legacy born from his coerced confession in a small windowless room, were now being read to the man suspected of his own murder. It was a final, tragic, and powerful testament to how one man's case had changed the very language of justice in America forever. The Miranda decision was about protecting the individual from the power of the state in a criminal proceeding. But what happens when the court is asked to weigh in not just on the rights of one person, but on the levers of power that control our entire political landscape? What happens when the case isn't about guilt or innocence, but about who gets to speak, how loudly, and who gets to fund our democracy? The answer arrived in 2010, and it wasn't a quiet verdict. It was a legal earthquake that reshaped the very ground beneath our political system. It's a case with a name that has become a lightning rod for debate, a synonym for big money in politics. Citizens United versus the Federal Election Commission. And it all started, believe it or not, with a movie. The year is 2008. The presidential primaries are in full swing. A conservative nonprofit group called Citizens United has produced a film. It's called Hillary, the movie. And it is, to put it mildly, not a flattering portrait of then-Senator Hillary Clinton, who was a leading candidate for the Democratic nomination. The group wanted to make the film available on demand through cable services, right in the thick of the primary season. But there was a problem. A big one. It was a law passed in 2002 called the Bipartisan Campaign Reform Act, better known as McCain-Feingold. This law was designed to get soft money, large unregulated donations out of politics. One of its key provisions banned corporations and unions from using their own money to air electioneering communications within 30 days of a primary or 60 days of a general election. So what was Hillary, the movie? Was it a genuine documentary, an exercise in free speech protected by the First Amendment? Or was it a 90-minute attack ad? A piece of electioneering communication designed to tear down a candidate right before people voted? The Federal Election Commission, the government's watchdog for campaign finance, saw it as the latter. They were ready to block its broadcast. Citizens United sued. They argued that the McCain-Feingold Act was censoring them. They claimed that the government was telling them, a corporation, that they couldn't speak out about a political candidate. At first, the case seemed narrow. It was about whether this specific rule applied to a video-on-demand movie. But when it reached the Supreme Court, the entire game changed. The court didn't just want to rule on the movie. They asked the lawyers to come back and re-argue the case on a much, much bigger question. Should the Supreme Court overturn its own previous rulings that allowed the government to limit corporate and union spending in elections? This was the bombshell. This wasn't about one movie anymore. This was about a century of campaign finance law. It was about a fundamental question that cuts to the very core of American democracy. Is money speech? And if it is, do corporations, these legal entities we create for business, have the same First Amendment free speech rights as individual human beings? The nation held its breath. On January 21, 2010, the answer came down in a deeply divided 5-4 decision. Writing for the majority, Justice Anthony Kennedy laid out a revolutionary new vision of the First Amendment. He argued that the identity of the speaker does not matter. The government, he wrote, cannot engage in censorship by telling a corporation it can't speak, any more than it can tell an individual to be quiet. He said, and this is the core of it, that restricting a corporation's ability to spend money on political ads was the same as restricting their speech. To the majority, the McCain-Feingold law was a muzzle, and the First Amendment forbids the government from placing a muzzle on anyone or anything that wants to talk about politics. The decision was a stunning victory for Citizens United, and a seismic shock to the political establishment. But there was a furious dissent. Justice John Paul Stevens, writing for the 4 dissenting justices, fired back with one of the most passionate dissents in modern history. He argued that the majority had just opened the floodgates. He warned that corporations are not people. They have, in his words, no consciences, no beliefs, no feelings, no thoughts, no desires. Their sole motivation is profit. He predicted that allowing them to spend unlimited funds to influence elections would undermine the integrity of elected institutions across the nation. He wasn't just disagreeing. He was sounding an alarm, a 5-alarm fire bell. warning that the court had just given powerful corporate interests a megaphone to drown out the voices of ordinary citizens. So who was right? What actually happened after the ruling? The impact wasn't just theoretical. It was immediate and explosive. The Citizens United decision itself didn't create the entities we now know as super PACs, but a lower court ruling just a few months later called SpeechNow.org v. FEC took the logic of Citizens United and ran with it. If corporations and unions can spend unlimited money to advocate for or against candidates, the court reasoned, then it stands to reason that groups can be formed for the sole purpose of raising and spending unlimited money from those sources. And just like that, the Super PAC was born. These weren't your normal campaign committees. They had one rule. They couldn't coordinate directly with the candidate's official campaign. But that rule proved to be paper-thin. Super PACs could, and did, raise limitless sums of money from corporations, unions, and billionaires. They could then spend that money on anything they wanted: TV ads, online campaigns, mailers, as long as they didn't officially coordinate with the candidate they were supporting. The result was a tsunami of cash that crashed into American elections. In the 2008 presidential election, before Citizens United, outside groups spent about $144 million. In 2012, the first presidential election after the ruling, that number skyrocketed to over $600 million. By 2020, outside spending from super PACs and other groups topped $3 billion. But it gets even murkier. The ruling also supercharged the rise of so-called dark money. Certain types of nonprofits like 501(c)(4) social welfare groups could now also spend unlimited amounts on politics. But unlike super PACs, they don't have to disclose their donors. So, a billionaire or corporation could give tens of millions of dollars to one of these groups. That group could then run millions of dollars in attack ads, and the public would have absolutely no idea who was paying for the message. The money was a ghost in the machine, pulling levers from the shadows. This case fundamentally changed the sound of our democracy. It redefined who gets to speak and how loudly they get to do it. Proponents argue it was a victory for free speech, that more speech from any source is always better in a marketplace of ideas. They say it leveled the playing field, allowing corporations and unions to counter the powerful voices of the mainstream media. But critics argue that it created a system where the wealthiest donors and corporations have a vastly disproportionate voice. They say it forces candidates to spend more and more of their time fundraising, listening to the concerns of a tiny number of mega donors instead of their actual constituents. It's why your TV screens are flooded with negative ads paid for by groups with patriotic-sounding names. While the true source of the money remains a mystery, it has made our politics more polarized, more expensive, and for many more toxic. Citizens United v. FEC wasn't just a case about a movie, it was a case about power. It asked the question, in the arena of American democracy, does the size of your wallet determine the size of your voice? The Supreme Court answered with a resounding yes, and we are all, for better or worse, living in the world that decision built. The aftershocks of that legal earthquake continue to shape every single election in America. It's a stark reminder that the court's decisions don't just interpret the law, they construct the very reality we live in. They can define a corporation as a speaker and money as speech. But this raises an even more profound question. If the court can expand rights to legal fictions like corporations, what happens when it re-examines the most intimate and personal rights that actual people hold dear? What happens when the battleground of the law moves from the campaign trail into the most private spaces of our lives? The bedroom, the doctor's office, and the wedding chapel.